All right. Hi, everyone. My name is Chris Richardson, President and General Counsel of BDB Solutions. Today, we have a special guest. We're going to talk a little bit about the state of immigration, visa retrogression, some of these student revocation issues. I'd like to introduce David Bier, who's an immigration analyst over at the Cato Institute. David's been with Cato for quite some time now, and he is a guru in immigration. He writes op-eds for the New York Times and all the big papers. I see him on TV all the time talking about immigration. So a great person to have, who's also probably the best immigration statistics guy that's out there. Really great understanding of the immigration statistics as they are. So, David, thank you for joining us today.
Thanks for having me on.
Yeah. Let's start off by talking a little bit about, in our EB-3 world, we have a ton of students, F1 students, visa holders. And I'd love to hear your thoughts on the dramatic increase in revocations and what you're seeing on your end with the revocations.
Yeah, so it really looks like the Trump administration has decided that they are going to use any involvement in the criminal justice system whatsoever, even arrests or traffic violations, anything to revoke student visa holders' status in the United States. This is a monumental shift, as you're aware, from what has happened in the past. Yes, we had DUI kind of being the standard case that you'd see come up that isn't really in the statute. There's not a clear statement from the government on what conduct will result in your CVIS being revoked. So that really, it does not put students on notice about what types of conduct to avoid, what issues could arise if they are charged or cited for any violation. So it is a confusing and difficult situation for students to be in because of the fact that we don't have that clear guidance. We don't know. We are inferring from what we have seen that there is this new marching orders to revoke anyone who has citations or arrests on their record, even if it didn't result in a conviction. We've seen cases where individuals were arrested but then never charged because they were innocent of the offense, and yet their CVIS is still being revoked because they're not analyzing in detail. They're just taking in whatever information they receive from local police and then basically applying a blanket policy. So it is a difficult world to navigate when you don't know exactly what the policy is. We haven't seen, as far as I know, we have not seen any memoranda from the administration that specifies exactly what they're doing here. So it is remarkable. And then, of course, you have the separate issue of revocations for involvement in protests and other perfectly lawful conduct. And those things are getting conflated in the public narrative and in the media and even by the colleges themselves, because they're, they might be looking up, does this student have any criminal convictions, and they're not finding anything. And so then they're inferring, well, that must be because of something they wrote on social media or something like that. So it is creating an even greater climate of fear around speech because of the uncertainty about exactly why people are getting their status revoked. So it is
It's
confusing
interesting.
and difficult situation to navigate.
Yeah, when I was a visa officer, we had automatic revocations for DUI, but very, very limited. And I think most people, they're getting this by email, like, right, like whatever email you put basically in your DS-160, you're getting an email from the embassy or consulate that issued your visa, essentially saying, hey, guess what, your visa's been revoked. And so a lot of people don't actually know their visa might be revoked because they might have put some other email in that chat box.
Yeah.
um, and it just opens up a lot of areas for fraud, for people being taken advantage of as well, when you don't have like a transparent process with that. But
Yeah, you
switching.
can't look up. You can't
No,
look up.
no,
Well, is this legit? Like, is this a actually legitimate grounds for
yeah,
inadmissibility or deportability?
no,
So,
yeah.
it is creating a lot of confusion and problems
And
for
I guess
students.
that's sort of the point is they, they want students to be on their guard. Switching gears a little bit and thinking about the employment based immigration system.
Yeah.
We have, at least in the EB-3 unskilled world, a ton of issues around the visa bulletin and visa retrogression. Could you talk a little bit about what is the visa bulletin? And I know you know what this is, but what is the visa bulletin? What is visa retrogression? Where's all this? What is all this stuff?
Yeah, so the visa bulletin is where an applicant is going to go to look up whether they're eligible to either file or receive a green card or immigrant visa. And so that is what the State Department publishes each month. They
Mhm,
publish dates, and so you are looking at your priority date, um, and which is based on your date of filing, and
mhm,
then you're going to look and see if your priority date is before or at the date listed in the visa bulletin, in order to assess whether you can either file or be approved for a green card or immigrant visa. And so this is the method for regulating the number of applications received by the State Department and then regulating the number of green cards approved because of the green card caps and limits. So each category and each
mhm,
country has a separate limit. So the visa bulletin is broken down into each category, and then you have the major ascending countries, and then every other country. So you typically see India, China, Mexico listed,
mhm,
Philippines sometimes, and then all other countries are thrown in the rest of the world bucket, which we in the immigration policy world called row. The
mhm,
row countries are it's the rest of the world. That's everyone else has their own priority date. And that's really because the main countries are the most populous countries: India, China, the Philippines. These are the largest sending countries. They'll
mhm,
run up against the country cap limit,
mhm.
and then the rest of the world has to deal with really the overall limit for the category that they're
Mhm.
applying for. And
I
so that's what creates these
retrogression.
delayed. The retrogression is then the date. That means that the date is not the current date. It means
Mhm,
that it has retrogressed and they've moved the date back away from the current date. So if you're filing right now, you won't be able to apply right away
mhm,
for a green card. Right now, for the EB-3 category, you're looking at over a 4-year retrogression. So only
mhm,
people who applied about 49 months ago will
mhm.
be able to apply for an EB-3 other worker category. Um,
Yeah.
with,
What is like the legal basis for the visa bulletin, and I mean that from like a standpoint of like where do these rules come from? To the extent that like where does like the visa bulletin written in the INA, where does like all of this stuff coming from?
yeah.
From what you understand, like how
Yeah.
is this even a thing in the law?
Yeah, so in Section 203 of the Immigration and Nationality Act, there is a provision that requires that the State Department maintain a list of the applicants for immigrant visas, and then to process people in the order in which they applied.
Hmm.
And so that's really the general authority for the State Department to create a mechanism by which they're regulating the number of applicants and approvals for green cards. And then really the visa bulletin is just their mechanism for doing that. And it's it is there is a lot of uncertainty within the visa bulletin because
Yeah,
they don't actually know
we
exactly how
don't
many
know.
people are going to apply
Yeah.
in any given month, or how many people or how many applications will get to the point where they can be approved. And so it's kind of a guesswork by the State Department. How many people are going to apply? How many people, how many applications are we actually going to get through this month? And so that's where there's a lot of uncertainty and
It
guessing that goes
sounds
on
so
about what
easy to
will
me.
happen.
It sounds so crazy to me as a lawyer, just because it's like, okay, so what the law says is you're supposed to maintain this list, and you're supposed to make sure that the first in get their visa. Okay, fine. Does the law say that, well, you can't file a case at this time? Does the law say, like, I just don't understand. Well, and I guess so my I'm just like ranting
Yeah,
at this point. But I do have a question in this.
yeah,
With the end of Chevron deference and the
yeah,
challenges that are coming around the administrative state, I don't like that word necessarily, but that's kind of what this is the administrative state.
yeah.
Do you foresee any industrious lawyer or somebody just being like, this whole visa bulletin thing is just made up, like, by these
Yeah.
government officials, and it just doesn't make any sense? But I don't know, well, knowing that, and I know as a lawyer, I wouldn't file that suit because I'd be terrified of like what then would happen, right? I think that's why
Yeah,
most lawyers are terrified
yeah, you could
about
get.
utilizing this, is because, like, yeah, that's great if you know what's going to come, but we have no idea if they get rid of the visa bulletin and get rid of visa
Yeah.
retrogression. We have no idea what's going to come after that.
Yeah, no, that's right. Look, there's certainly other mechanisms by which they could go about this. There could be more transparency about where your application is in the queue. They don't want that transparency because they don't actually process applications in the order that they are received.
Mhm.
They have a lot of internal policy rules around, well, who, if, okay, it's an EB-3 other worker category visa, so we're gonna spend a little bit more time investigating this employer than we would for
Mhm.
someone who's applying from a major tech company who, so they have all these different rules. We don't know all of those
Mhm.
rules, and exactly. I think there should be more investigation of that, really, like through Freedom of Information Act. And
Right.
but they do that is one of the reasons why there's this hostility within the State Department to it just having a transparent list where you can actually
Mhm.
look up, okay, here's your number, that these
Mhm.
are all the applicants that are listed in front of you.
Mhm.
And even if there's guesswork, you can actually see in real time like what the guesswork
Mhm.
is what is being done in terms
Mhm.
of how many applicants have just been opened up when the date moves.
Right.
And so, yeah, there could be a much more transparent process, but
Mhm.
there certainly a lot of hostility within the government to creating a more
Transparent
transparent
system. Oh,
process.
yeah. So someone right now in the EB-3 unskilled category passed away. I think they're only looking at cases from May 2021. We'll find out soon what
Yeah,
the new visa bulletin is going to say.
yeah,
Based on your estimates and thoughts, and also, like, you've studied the history of visa retrogression in general,
mhm,
it's probably going to stay about this way, maybe get a little bit worse.
yeah,
It may get a little bit better down the road, but in the visa bulletin is oddly very cyclical. I guess it's not that
yeah,
odd. It's very cyclical. Could you
yeah.
talk about in the past, when things have gone current? What have been some of the reasons why it's gone current again?
Yeah. So look, if you go all the way back, um, to the 1990 Act, which is really the authority for the creation of the current employment-based immigration categories, we had retrogression from the jump.
Mhm.
As soon as the category, the EB-3 other worker category was created, it was immediately retrogressed because demand was in excess of supply, and
Mhm.
it got worse throughout the 1990s. And then there was a period around 2001 when it went current, but that was really an illusion. And the illusion was created because the Department of Labor was just not processing labor certifications in any reasonable time frame. So you were looking at years-long waits in the labor certification
Mhm.
period. So by the time you actually got to
Mhm.
filing the petition, uh, the your date would have been, basically your date would have been current. So there was
Mhm.
this choke point with the Department of Labor that prevented uh,
Mhm.
basically a backlog from developing at the petition stage. And so then there was a period from 2001 on, and then you had the PERM rule, which was the reform of the labor certification process. And
Mhm.
initially, this was a huge, monumental shift and resulted in a streamlining of the PERM process. And then all of a sudden, all this demand that was hidden by the Department of Labor came online all
Mhm.
at once into the I-140 backlog, and that led to retrogression again.
Mhm.
And so you had retrogression basically continuously until I want to say 2015, 2016
Mhm.
timeframe. And really, what we saw during that time frame when it came current, or the dates progressed rather than retrogressed, was a lessening of demand following the recession, and the employment situation worsened so dramatically. I mean, people have blocked this from their memory, perhaps, but
Mhm.
2009, 10, 11, 12. I mean, these
Mhm.
were just one of the worst series of years for um,
Unemployment.
just the employment situation in the United
Yeah.
States. And so
Yeah.
there were a lot of workers available, domestic workers available,
Mhm.
and so they were able to work through the backlog in the EB-3 other worker category,
Mhm.
um, and uh, and so it improved, and then now we're seeing the opposite as demand. It really increased, spiked in a dramatic way during the Biden years. We're kind of seeing that play out now with big backlogs.
So I did have a. There was like one. There was like this. There was this time when I think it was the Bush administration or the Obama. Wasn't there like a year where basically USCIS just said everyone's current? Like,
Yeah, yeah,
like no
yeah,
matter what, we know what we don't even care. Everyone's just current.
yeah.
What can't they do that? Well, one, what was that about? Like when they
Yeah,
basically just said everyone in the pipeline, you're current, congratulations, and file.
yeah.
What was that about? And could they do that again?
Yes, they could do that again. The reason it happened is not something that the government has ever really uh, put out there publicly. The conversations that I've had with the people who were responsible for that decision was there was a conflict. The Department of Homeland Security was essentially, I mean, you go back to 2007, vast majority of the petitions are happening on paper, and the record keeping was so poor, they were not getting any real time information to the State Department
Mm,
to actually do any kind of rigorous estimate of what
mhm,
the date should be. And so the State Department, I want to I want to say retaliated essentially against the Department of Homeland Security and said, if you're not going to give us information that will help us set the date, then you're going to have to figure it out at the adjustment of status
Mm-hmm.
stage. And so they just opened the gates essentially to all that demand. And in 2007, you had this huge increase in adjustment of status filings. And
Mm-hmm.
so what they really did is they moved the choke point
Mm-hmm.
from the I-140 stage to the adjustment of status
Stage.
stage. And
Yeah.
so you had really from 2007 until um, 20, I don't remember exactly, but at
Mm-hmm.
least 5 years where you had 5 years worth of demand that was dumped
Immediately
into the
dumped out
adjustment
into
of
the process.
status
Wow.
stage
Wow.
of the process, which immediately after that, so it was, I believe, July of
Mm-hmm.
2007 when they did that. Immediately after that,
Mm-hmm.
they they
Put it back in.
retrogressed way back
Yeah.
the number of, and so basically you had retrogression
Mm-hmm.
reinstated almost immediately after
Yeah.
that, and then you had this long period
Yeah.
of retrogression. So yes, so the bottom line is it could happen. The issue ultimately is that the State Department has, and the Department of Homeland Security has decided that the best way to regulate and implement the caps is to limit the number of adjustment of status filings and immigrant visa filings rather than at the approval stage.
Mm-hmm.
And there is uh, some textual basis in the law for that position, but it's not clear exactly what the law says. The law says that in order to file an adjustment of status, there has to be an immigrant visa available under the caps.
Mm-hmm.
And so the debate is, either you could say, well, the State Department and Department of Homeland Security have to project whether
Mm-hmm.
there, by the time we get through this backlog, whether there'll be any visas left for this applicant who's applying. And that's what they basically do now is we're not going to allow you to apply if we project that there will not be an immigrant visa available after denials and approvals and going through all the applicants that apply.
Right. But why not
The other way to look at it is to say there's an immigrant visa that's available at the start of
yeah,
every year.
of
You
every
can
year? So
start
just
these
give it to them
caps
all. And then like after they're all actually used up,
Yeah,
then you can retrogress, right? Like I just
exactly.
don't
Yes.
understand
Yeah.
like why do they just don't do that?
Yeah. So it is. Yeah. I mean, it's
Yeah.
historical practice at this point,
Yeah.
and you know, really, they don't want to deal. They don't want to deal with all these additional applications that would
Hmm.
come in,
Yeah.
and they look at it as an incentive to file,
Hmm. Hmm.
which in their frame, um, they kind of conceive their job as limiting demand
Hmm.
for these categories.
Yeah.
Their goal is not to maximize the number of people who get to apply for immigration benefits.
Hmm.
They conceive of their job as the opposite, is trying
Yeah.
to limit demand.
Yeah. So we got a question up here. When do you think immigration cases from 2020? Well, they're actually current now, I believe. Let me go check what the visa bulletin specifically says, but I think from let's see, we have April isn't out yet. I assume April will come out in the next couple of days. But yeah, if you filed in 2020, in theory, your case should be current now, and you should be in the queue to be interviewed. Now, that doesn't always obviously happen because the State Department, is slow. They got all these other things going on. But yeah, for other workers, cases that are after February 1st, 2021, can be issued, although the cases after May 22nd of 2021 are the ones that can be filed. So there's Chart A and then there's Chart B.
Yeah.
And let's see if so the work permit is you have to file the work permit at the same time as you file the I-485. And actually, David, I'm going to ask you a question
Sure.
about that in a second. Is there any legal basis for why you just couldn't file a work permit before you file the I-485? Like, I think I've seen that
Yeah.
that they have to be tied together, but do they actually have to be tied together?
Again, there's no, there doesn't really have to be. Look, at the end of the day, the INA gives the authority to the Secretary of Homeland Security to
Mm-hmm.
decide who is authorized to work in the United States. And
Mm-hmm.
so there's not really a rigorous standard that can be applied here. And so you're really falling back on this precedent that,
Mm-hmm.
has been created over the years.
Hmm. So, David, like, if there's so much like obscurity around the visa bulletin and so much like they just kind of make this up as they go
Yeah,
along,
yeah, yeah.
why has it been this way for 30 years? Like, why has nobody stepped into DHS or the State Department and said, you guys are just making all this stuff up? Like, why has there been no president of all these presidents we've had since Clinton who's
Hmm.
basically said, you know what, you guys are making all this stuff up. I'm going to make it up in a way that actually benefits both employers and foreign nationals. Is it that there just isn't that kind of desire in the government, or is the government fearful of it? Like to me, and we've been on our end at BDV, we've been working and lobbying. In fact, we just
Yeah.
hired John Bestlise from the chamber to help us with this stuff. But it just seems like a lot of the stuff is made up. And when you bring it to the government's attention, they're just like, well, we've been doing it for this way for 30 years, so kind of leave us alone.
Yeah.
Like, what are your thoughts on why there hasn't been a movement to change the way things work in government in that way?
Yeah, so I mean, it's a great question, and if you're talking about just the executive branch incentives here, it's more work for them to change the system, and you're talking about increasing the amount of applications. You're incentivizing more applications, and
Hmm.
really, if you go back and look at the history, the employment-based categories have been maligned since their
Hmm.
initiation. And
Hmm.
you read the reports. The Department of Labor sees the whole thing as fraud.
Hmm.
Um, Basically, if it was up to the Department of Labor, we probably wouldn't have employment-based immigration.
Hmm.
It really comes back to the attitude of these agencies is extraordinarily hostile to immigration,
Hmm.
to doing their jobs. They don't want to increase the number of applications or create more work for themselves. So the incentives are all bad. There's no like positive incentive there for them to like, well, we don't get like reward if we do a better job or
Hmm.
improve the process. It took a literal just collapse of the labor certification process
For them to change
in the
that.
2000s to then create this perm rule, which no one I mean at the time it was the Bush administration and
Hmm.
it was there was no way for us to fulfill our jobs. We're getting lawsuits constantly
Hmm.
over these delays. We're kind of in that position now again, in a
Yeah.
way. The
Yeah.
lawsuits and the delays in the labor certification process are getting
Yep. We're
extreme.
right
But
back to
but
it.
again, there's no there's no real incentive to come in and
Mhm.
change it. It's the applicants and the employers are the ones who bear all the costs. The government
Mhm.
really doesn't, bear any of the costs of
Right.
having an inefficient process, and it actually undermines. This is what I've seen a lot working on Capitol Hill. it
Hmm.
actually undermines their arguments to Congress for more funding. If the system gets fixed by executive order,
And they can't get
then
more money. That's
yeah,
crazy.
then they can't, like, their whole argument, they come to Congress every time and they say, "We need more appropriations. You need to give us more money. We can't do
Hmm.
our jobs." And, you and I, we could come and say, "Well, there's 1,000 things you're doing that you don't need to be doing. You could just streamline this process and get rid of
Right,
all this." And
right.
and but there's no incentive to do that because then it just takes away their argument for
It's just
funding, which is
wild to
really
me.
their main
That's their main thing. I
that's their
remember,
main metric of success.
because during COVID, they were like, well, we need to increase premium processing fees. We need to add all these fees. Or even
Mhm.
like this asylum fee. There's
Yeah.
nobody filing asylum
Yeah,
anymore.
yeah.
And yet I'm still paying an asylum fee, right?
Yep,
Like
yep,
nobody, like the USCIS is so great at being like, we
yep,
need more money now, or we can't fix anything. And then
yep.
things get worse. And then it's like nobody ever revisits the fact that we gave them money for something like a while ago.
Oh, yeah, the
So,
EB-5, I mean,
oh
the
yeah,
EB-5 category is probably the
yeah,
best example of this
yeah,
because initially they were basically paying the same fees as every other
yeah.
applicant, and then they did a reform,
Mm-hmm.
and allowed them to increase the fees a lot, so now they're paying tens of $1,000s of fees, and and the problem got worse. I mean, the
Yeah,
delays got, even
got
worse.
worse.
They hired
Yeah.
all of these economists now. They have this
Mhm.
huge office
Right.
where they're just going through and analyzing these
Right.
applications in even more
Yeah.
excruciating detail,
It's
which is
crazy.
exactly what would happen
Yeah.
in EB-3 or
Yeah.
any other categories if we hired a bunch more people. They're just going to analyze these in more
Yeah.
detail, looking for fraud and looking
And
for
whatever else.
whatever. So yeah.
So last question. Then we're gonna cut off. But if you could talk to Elon and Doge and all these people, and they told you, "Hey, David, what are three things that we can do to fix visa bulletin, visa retrogression?" What would you tell them? Beyond, like within the context of what they actually could do. If they're like, you know what, you're right, David. All of this stuff is just made up. How would you fix it?
Yeah, I mean, the main thing to do would be to stop limiting the number of filings.
Hmm.
Basically, make the dates for filing at least current. So as soon as you get an approval for an I-140, you can move
Hmm.
right on and file your adjustment of status, receive your work permit, and be able to start working the job. That would be the best way to deal with it without increasing the numbers. I think there
Hmm.
are a number of different arguments for recapturing unused green cards and exempting from the cap the dependents of
Hmm.
the employees who are being hired. Those are longer shots. I think that the procedural change is already permissible under the law. We already have, two different dates that they're using, the dates for filing versus the final action dates. So if you make the dates for filing current, then that will resolve a lot of the
Hmm.
pain points for the applicants and for employers. And so that would probably be the number one recommendation. And we already have different dates for Department of Homeland Security versus the Department of State.
Yeah.
So you could even see further bifurcation and keep the dates
Mhm.
for filing retrogressed if the applicant is abroad. So I do think there are different ways to do this, any of which would be better than what they're
What we're
currently
currently doing. That's
currently
right.
doing. And of course, there is a lot of bureaucratic streamlining
Hmm.
that they should be doing and considering as well. That would alleviate a lot of the pain points in the actual application process um, that they should be considering.
Yep, 100%. All right, David. Well, thank you so much for joining us today. This was really, really insightful. Everyone, just leave your comments there, and BDB will get through and respond to them in time. But thanks a lot, David. And everyone, have a great day, great
Thanks,
weekend.
Chris.
Thanks, everyone. Bye bye.